People often want to know if and when their case may come to a settlement, that is, a resolution short of a jury's verdict. When the patient should do so is not so easy to answer because it's really not entirely within the patient's control. If there comes a point in a case when the individual you're suing or the entity that you're suing, if it's a hospital, when they come to the conclusion that it makes sense to begin negotiation of a settlement, that will commence a process that involves your lawyer, and there will usually be a back and forth of both argument and negotiation, often with the help of a mediator. You as the client have the absolute right to know the status of those negotiations, even though you may not be participating directly in them. Sometimes you are present when those are going on, but most often not. But your attorney has an ethical obligation to advise you when an offer is made so that you can discuss it, consider the pros and cons at that point in time, and make a decision, hopefully with the concurrence of your attorney. The right, however, to settle or not settle, ultimately, in the face of a given offer, remains entirely with the client. Hopefully their attorney gives them good, adequate, and thorough advice so that they know what the risks are, both on the upside and on the downside, because there will be both in any given case.